All right. So we're going into our second panel of the day now, cutting edge litigation. And I want to introduce our moderator, Jack Tuholske. Thank you. Professor Tuholske is an adjunct professor at Vermont Law and the University of Montana. As a Fulbright scholar, he taught courses in climate change, comparative environmental law, and additionally, he serves as the director of the Water and Justice program here at Vermont Law School. So, Professor Tuholske.
Good morning. The first thing I want to do is thank the students. You all have done an amazing job putting together this panel and bringing in really the cream of the crop in terms of TMDL litigation and the Clean Water Act. And I think it's a profoundly important subject because the Clean Water Act has worked in round one, right? We kind of figured out point source pollution. But watershed management and dealing with non-point source pollution is really the challenge we face as a society in the 21st century. And we have, for this panel today, some of the cutting edge ideas, if you will, about how to achieve a goal that we can all agree on. I mean, we all want clean water and healthy watersheds. We're still fighting about how to get there. So with that in mind, we have three panelists today, and they come from a wide variety of backgrounds here. And I'm not going to make a long introduction. I'm going to start here with Richard Smith, who has come all the way from Washington. He is a brother in arms of mine. We can relate because we have both been in the private practice of environmental public interest litigation in a private law firm for more years than either of us can remember. So with that, Richard, the podium is yours. Thank you.
Okay, thank you very much. I'm very happy to be here. Thank you all for your attention this morning. My name is Richard Smith. My law firm is called Smith & Lowney. I've been in Seattle practicing private public interest environmental law since 1993. Most of my practice is Clean Water Act citizen suits, and that's led me to be involved in many other aspects of environmental litigation, including fairly recently my first foray into TMDL litigation, which I'm going to be talking about today. I'm going to be talking about something called the Constructive Submission Doctrine, and I'm also going to be describing the situation in the Spokane River, which is a very troubled river in eastern Washington. So, under Section 303, every listed water body has to have a TMDL. That's what the Clean Water Act says, right? We've heard that already today.
Richard, do I need it?
No, I got it. So the Clean Water Act, Section 303, envisions a multifaceted, multi-step process for water quality-based regulation involving continuing planning process and water quality management plans. Part of this is supposed to be formal prioritization of waters needing TMDLs. I didn't find any of this stuff in Washington State. I looked for it. I asked for these plans. I expected to get, okay, this is our planning process, here it is, here are the plans. None of that stuff exists, really. When push comes to shove, they point at a collection of things. Oh, this constitutes that. It doesn't really exist. And by many measures, I would say from my perspective, as someone working with concerned citizens, community groups, environmental organizations, TMDLs are pretty much a paper exercise. That's kind of what I've seen. They don't often, I'll have a case about a polluter on a particular waterway. Oh, there's a TMDL, what does that say? You look at that, it means nothing. Great, all right? But it is the powerful tool that does require the numbers, like Nina Bell said. And I think that's the important part. Now, here's the common situation. The TMDLs, the state doesn't want to do them. So what do you do when the state doesn't want to do a TMDL? So the rule is that when the proposed TMDL is submitted by the state to EPA, the submission triggers the 30-day period for the EPA approval or disapproval. That's the EPA's obligation under Section 303D. It's only triggered by the state's submission of the TMDL. So the problem that the first TMDL issue, back starting in the 80s, was that the states were refusing to do them. So there's no handle there because nothing requires the state to do it. The obligations in the Clean Water Act are all on, the enforceable ones are all on EPA. So some lawyers, I don't know who they were, but in the Midwest, they were concerned that there were no TMDLs for Lake Michigan. So they concocted this theory that the courts bought called constructive submission. And the idea is that if the state is refusing to do a TMDL, that is the same as submitting a TMDL that's obviously inadequate, and that triggers EPA's obligation to review it, approve it, disapprove it, and if disapproved, to adopt their own. And it's a kind of a unique thing in environmental law. I haven't really been able to find very many analogies when I was researching this. Scott versus the City of Hammond, that's the seminal case. Since then, there were quite a series of TMDL constructive submission cases through the 1990s. And Alaska Center for the Environment versus Riley is representative one. This was one of the earlier ones, and this came out of my home court by the Judge Rothstein, who I ended up having in my case, which was a fortuitous circumstance. If you want to know more about the history of the constructive submission doctrine, this American Littoral Society versus EPA case has a pretty good summary of those efforts. And these were kind of programmatic. In that Alaska case, in the Western District of Washington, the environmentalists said, the states did not gun any TMDLs, none. So you, federal court, have to make this system work. And our wonderful activist, Judge Rothstein, said, yeah, let's do that. And that's what happened. And that was repeated in a number of states. Usually resulting in court orders, consent decrees, various types of mechanisms that were designed to set schedules for the submission of TMDLs. In my state, Washington, another shout out to Nina Bell, her organization brought the programmatic TMDL case in the 1990s, and we got a settlement agreement that incorporated an EPA, State of Washington Department of Ecology memorandum of agreement that included a schedule for completion of TMDLs for all the waters that were listed on the 1996 303D list. Right. The constructive submission litigation kind of came to a head around 2001, 2002, and this is the Ninth Circuit case. I think Hayes was first. I think I've got that backwards. I think that Baykeeper was following Hayes. But those decisions in the courts of appeals kind of closely cabined the constructive submission doctrine. They said that there may be, that a constructive submission is viable only when the state fails to submit any TMDLs and has no plans to remedy the situation. And by this time, that really wasn't, it was hard, that probably didn't exist anywhere. You know, this San Francisco Baykeeper case was in California, and the claim was that they weren't submitting the TMDLs fast enough, and the court said, no, that's not, this is too gray. We're gonna limit constructive submission to when they're definitely abandoned it, clearly announced no TMDLs, not going to fix this, not going to do it, right? And a lot of people, I think, thought that was the end of the constructive submission doctrine. And the litigation tapered off sharply after that. And I don't know if those type of programmatic constructive submission claims would succeed anywhere. Maybe there is some state out there that's absolutely refusing to do them and has none to show for it and has owned up to that, and it would work. But I got a call about the Spokane River. My clients, the Sierra Club and Center for Environmental Law and Policy, were all worked up that the state was refusing to do a TMDL for PCBs in the Spokane River. And so I looked up some of the early constructive submission cases. I was like, yeah, I can do this. Only after I agreed to do that did I see that Sierra Club, the Baykeeper case. I was like, how am I going to do this now? But we figured it out. Let me talk a little bit about the Spokane River. So, the Spokane River is really hot with PCBs. The Spokane River starts in Idaho. This is, as you can see in the little inset, this is in the eastern side of the state of Washington. The river comes across from Coeur d'Alene, across the state border, runs through the city and county of Spokane, and then goes into the Spokane Indian Reservation before its confluence with the Columbia River. Okay. It's been 303 delisted based on PCB contamination of fish tissue for many years. The Spokane Indians are really unhappy about this. They consider the PCB contamination in the river to be impairing their their treaty fishing rights. Kind of a big deal for them. The PCBs, where do they come from? They're not, I don't know if people are familiar with PCBs. PCBs are very toxic. They're considered by my state persistent bioaccumulative toxic chemicals. And they don't go away. They persist in the environment. They accumulate in fatty tissue of small creatures, bigger creatures that eat them, the fish, and then that's how people get exposed to them, by eating the fish they catch. Where are the PCBs coming from? Oh, here's the criterion. These are really toxic. These are really low numbers. 170 picograms per liter. This is one of the defense counsel in our case described that as trying to find a couple of basketballs in a stadium full of basketballs, or what's it, ping pong balls, something like that. It's really small, really hard to find. And so these are the levels. Keep those in mind for a second. Let's look at the 5.3 nanograms per gram. That's the state tissue. That's what the state standard is. Now this is, I don't know if you can see that, but these are fish tissue numbers from the Spokane River, and they're all way above the 5.3. Never mind above the more stringent Spokane tribe of Indians criteria. So this is a pretty serious problem. It is tending to get better. So this has been a priority for the Department of Ecology for years to do this TMDL for PCBs in the Spokane River. And they issued a draft in 2006. Well, they did this whole analysis. This just shows that the loading goes up as you go further down the river. And the Spokane Indians are really getting it there. That's all that shows. But that's my case. So the state issued a draft TMDL in 2006 and then got scared. And with the EPA, they kind of freaked out, and we have this great emails saying this is going to be, so ugly to do this. This is going to be, very sarcastic. This is going to be so much fun to implement this. There are only a handful of direct dischargers on the river. They don't want the TMDL because they don't want the water quality-based effluent limitations in their permits that would be based on the waste load allocations. They don't want those numbers. So the state was feeling kind of burned by a 10-year-long battle over another TMDL on this river, and they just were kind of exhausted and didn't do it, and they just really lacked the will to put these numbers in the TMDL document that would then result in numbers in the NPDES permits. So they essentially made an agreement with these dischargers. They said, if you guys sign up for our task force and you participate in this task force and you provide some funding for it so that we can do source tracing and try to figure out what's going on here and make a collaborative effort, then we will hold off on the TMDL, and we will call this a straight-to implementation plan. And we will skip the difficult thing with the TMDL and numbers and all that stuff. Let's just go straight to fixing this. That was their idea. Some of the environmentalists in the community bought off on this. And there was a split in the environmental community in Spokane. It's actually kind of controversial. And some folks think that this is a good approach. Let's save all that hassle about the numbers. My clients want the numbers in the permits. And they want the numbers in the permits so that the rest of the framework can work. The water quality trading, this is really a good situation, I think, for if water quality trading can work anywhere, it seems like it should be here. You put these really tight restrictions on these handful of dischargers, municipalities, a couple of industries, aluminum plant, paper plant, stuff like this. And they will have an incentive to spend money in order to get some relief from having to meet those very tight requirements. And that's essentially what they're doing now. They're essentially trading now. They're just doing it without any framework, without any numbers, without any certainty or anything. It's all voluntary. My clients didn't like that at all. So we decided that we would bring a constructive submission claim and we would say, well, this is different than the programmatic claims that were cabined by that San Francisco Baykeeper case. This is about a single water body, and I looked through all the case law, and the only case that I could find about a single water body was the Seminole case about Lake Michigan. So we hung it on that, and the judge bought it and said that the state has said that they're not going to do a TMDL. This is a problem. The judge actually did not find constructive submission. She said the doctrine lives in our case. The doctrine lives in this kind of circumstance, which I guess is the cutting edge part of it. You know, you can do a constructive submission claim for a single water body. You know, if it's not being done and the state has basically disavowed the TMDL, and the judge managed to find for us on an APA, found that the EPA's decision that the state's plan was okay was arbitrary and capricious and ordered them to go back and do a new plan. We're now in litigation over whether the plan is good enough. EPA has stretched out the schedule for 15 years to do this TMDL, giving them a bunch of off-ramps and whatnot. We're saying, no, the information's available now. They have this last study they're going to do. They're going to, be able to put all this together. So we'll see what happens. So these are the implementation tools. So what they're doing with this straight to implementation thing is they're basically trying to use these concepts of particularly water quality offsets, which is our state regulation on water quality trading. Washington has has really written unlike many states I understand, has really kind of defined all these things. They did all this work to define all these things, and now they're trying to just ignore them. And we want them to go into the TMDL framework so that these things, with this environmental integrity safeguards provided by these regulations, can work, rather than having this kind of informal hope for the best kind of trade-off agreement with these dischargers. That's kind of the crux of what's happening in our case. So we also want the reasonable assurance. And I think that this is another piece of this that I'm keenly interested in. And there's on another TMDL in the Spokane River, there's litigation going on what that means. And this is my mission today to find out more about this. The other thing is that there's this thing. They developed a policy. EPA and the state developed a policy about different categories for the impaired water bodies list. And they're supposed to be, category 5 is the 303D list, and that's what needs a TMDL. And then they've got this other thing, category 4B, which is the water body's impaired, but we have this other kind of plan. So what they should be doing in the Spokane River, if they want to do what they're trying to do, is put the river as 4B. That would be politically difficult for them, and perhaps not stand up to challenge, so they haven't done it. But this is another, I guess the theme here is that the TMDLs are necessary or important because they're the tool for the citizens to get a handle on this stuff, and they're the framework with the numbers that forces everything into an actual controlled regulatory framework. Otherwise, the straight to implementation thing, which could possibly be an okay concept in some places, is very wishy-washy, unenforceable, and my clients are convinced not going to work. So the future of water quality-based regulation and TMDLs, I don't know. you know, I think that not everything needs to have a TMDL to be fixed, but this is the tool for the citizens. This is the tool for my clients. This is where we go to get a handle on this thing, and for that reason, TMDLs are important, and my clients and I are going to keep trying to use this as a handle. So that's kind of my little summary of that, but I really liked what Nina Bell said in the previous panel, and I'll say this one more time, is that the TMDL is what gives you the numbers, and those numbers go into the NPDES permits, and that's what's important about this, at least in the context of the Spokane River and PCBs, which is where my experience is. Thank you very much.
And another gold star for keeping within the allotted time. Our second speaker is Matt Rota, and he is going to take us out from the confines of how do we enforce an individual TMDL and how do we clean up the Spokane River to a much broader and equally as cutting-edge theory about how do we use the TMDL process to address pollution on a watershed scale. And this case, this situation, both complements and contrasts with what you heard about the Chesapeake Bay TMDL. Matt is the Senior Policy Director for the Gulf Restoration Network, deeply involved in trying to find ways to solve one of our most serious environmental crises, the dead zone in the Gulf. So the stage is yours.
Thank you very much. All right. I just switched it because I don't know if that was the old PowerPoint that I checked. Anyway, hey, I am Matt Rota, and I have one of the distinction to probably be one of the few non-lawyers in this room. My degree is in environmental management, but I do a lot of work on policy and legal things. And what I'm going to be talking about today is the Gulf dead zone, and just to see where we are. Could I have hands raised if you know if I talk about the Gulf dead zone, a general idea, right? Okay, all right, that's good. I'm going to be going over a little bit, but now I know I can rush through that part so I can get a gold star. So dead zones are spreading throughout the world. It's kind of one of the biggest pollution issues in the world today, and we're seeing more and more of them with population increases, with changing temperatures, things like that. I can't see it real well, but you can, let's see, all of these little white dots all over the place. These are all dead zones. These are all hypoxic zones, basically 2 milligrams per liter of dissolved oxygen or less. So we aren't alone in this issue. Zooming in a little bit, here is the United States. And as you can see, once again, this problem is rampant throughout our country, throughout the world. And then I'm going to be zooming in, I'm going to be talking about the dead zone, which forms at the bottom of the Mississippi River, right there. And this gives you the idea of how big of an area we're talking about, and one reason why this is such a difficult issue to work with is we're just dealing with scale. We saw how difficult this is with the Chesapeake watershed, which, you know, yes, you're very large, but not as big as what we're dealing with here. 1.3 million square miles. It drains 31 states. It drains it also touches 2 Canadian provinces, 42% of the continental United States. And it feeds down and feeds the second largest dead zone in the world, second only to the Baltic Sea. So just kind of to put those two images together right there. Again, we aren't alone, but we have some particular unique areas where it's multi-jurisdictional. I didn't do the math on how many EPA regions, how many core districts, different states. And so just a lot of jurisdictional issues. The National Academy of Sciences came out with a report in 2008, I think it was, calling the Mississippi River an orphan, saying that basically there is no agency, no organization that is really taking responsibility for pollution issues in the Mississippi River and thus the Gulf as well. So getting into, as you know, the dead zone is caused by nitrogen and phosphorus pollution. And here are a couple graphs of just the sources of the delivery to the Gulf. As you can see, no, you can't see that now, can you? There you go, wrong button. So green is agricultural, basically, corn and soybeans specifically. So half of the nitrogen, half of the nitrate that gets into the cause of the dead zone comes from corn and soybeans. So there's that, and then I guess the other important one to look at is the urban population, which would be your more typical point sources. So 12% of the phosphorus and 9% of the nitrogen. So it is very much an agricultural problem. Not that we should be ignoring the point sources, because they are also not properly regulated in implementing water quality-based effluents and things like that. But if we're going to fix the dead zone, we need to reduce significantly the agricultural pollution. We know where this pollution is coming from. Here, the darker the red, the more nitrogen and phosphorus we're seeing, and it's coming from basically the I states, Iowa, Indiana, and Illinois. That's where our big corn and soybean production is. Also, I think this is going to be talked about later, so I won't get into it. But also, these areas are have significant amounts of tile drainage, which basically acts as a main line for nitrate to go straight, not get processed at all, go straight into the Mississippi River. Just to give you another perspective, more on a watershed level, once again, this is the delivery of nitrogen and phosphorus to the Gulf of Mexico. Just to make sure everybody knows what we're talking about when we're talking about dead zones, here's a little cartoon about it. You have nitrogen and phosphorus pollution coming down the Mississippi River. It gets to the Gulf. There are physical and chemical processes that happen that cause stratification, and you have these algae blooms. The algae sink to the bottom of the ocean. They use up all the oxygen, and that oxygen does not get mixed back up, and so you have dead zones where critters either have to swim away or suffocate. Like I said, it comes from agricultural pollution as well as point source pollution. So we need to be addressing both of these when we're addressing the dead zone. Here's a picture of the dead zone. There I always have reporters saying, I want to get out into, I want to see the dead zone. Well, that's one of the issues of it, is that it's kind of an out of sight, out of mind issue where you have he's trying to get warm. It happens on the bottom section of the ocean, but this is Dr. Nancy Rabelais, who's been measuring the size of the dead zone since 1985. Here's a picture from last year, I think it was, of dead critters on the bottom of the area where the dead zone is, where they basically suffocated and died. Little history of the dead zone. It changes every year. You can see here, just to give you a little perspective, that's the mouth of the Mississippi River. Right over here is the border between Louisiana and Texas. So this basically forms on the shelf of the Louisiana shelf. Sometimes it gets over into Mississippi a little bit, gets over into Texas a little bit. But here it is this in 2002, and just also notice that it doesn't really get much past here, because that's where the shelf really drops off. So it's confined geographically by the shelf. 2002, 2003, you can see it was a little smaller. 2005, it was actually pretty small. Does anybody remember what happened in the Gulf in 2005? Yeah, we had some meteorological activity down there. Katrina, Rota, it was a very active hurricane season. And one of the interesting things is that hurricanes, when they get in there, they mix that water back up and can actually stop or hamper the dead zone a little bit while it's coming through. Scientists show that it settles back in once that disruption stops. But one thing that I joke about is that one way we can fix the dead zone is we just keep having more and more hurricanes, and then we don't have to do anything about it. 2008, we moved into Oz and Technicolor here, so that was the second largest ever. And now I just want to move on to this year's dead zone, which was measured. They measure it one time per year. They get out there for usually 5 to 8 days and go to all these different stations and get a really good measurement. And it was about 6,474 square miles this year, which was a little bit above, I hate using this word average because the average is way too high. As I'll be talking a little bit, the goal is to reduce it to less than 2,000 square miles, so it's almost 3 times the goal. And put it in perspective for you New Englanders up here, that's approximately the size of Connecticut plus Rhode Island, of an area on the bottom of the shelf that sea life cannot live. Dead zone isn't shrinking. It's kind of plateaued a little bit. We measure this in the 5-year running average, and that is what you can see right here is the black line is the 5-year running average. And so we've kind of plateaued a little bit, but we need to look at it in the context of this green line right down here. And that is the size that the current action plans say that we need to be reducing the dead zone to. So we're about 3 times where we should be. Not only does this pollution cause dead zones, but it also does cause local water quality problems throughout the basin. Just some examples of algae blooms that nitrogen and phosphorus pollution have caused just here in Louisiana a couple of years ago. Nasty stuff there, and then it also causes the issues in the Gulf. So, kind of what I was brought to talk about today is, I'm halfway through, is the legal action that's come up around this. So, I'm not expecting you to read that. So, 1998, EPA said that they expected all states and tribes to adopt and implement numerical nutrient criteria for their waters by 2003. And basically, if they don't, EPA is going to do it. And this basically didn't happen, and we've heard just from some of the past panelists that these numbers are important. Using narrative standards, how do you write a narrative standard into a permit? How do you use a narrative standard to measure edge of field effectiveness of BMPs, things like that? Having these numbers is really important if you want to have good goals and be able to make your way to those goals. And pretty much none of the states in the Mississippi River drainage have nitrogen and phosphorus numeric criteria. And EPA said you need to do this by 2003, and that basically didn't happen. Nobody did it. But we did make some plans. We had made some plans. We had another plan. We made another plan. We did all these reports and some more plans. That's the EPA Science Advisory Board plan. And then we had another plan in 2008. And we have another revised plan in 2013. And if you remember back to that graph, nothing really has happened since the time that we started developing these plans. In 2007, come on, there you go. Just right here from the EPA, overall progress has been uneven over the past 9 years. And now it's time for EPA and its partners to take bold steps relying on a combination of science, innovation, and collaboration. That's them basically saying, don't worry about that 2003 goal. We're going to work together and we're going to get this done. Gosh darn it. 2008, we filed a petition to EPA asking for numeric water quality standards and a TMDL for the Mississippi River and the Gulf of Mexico. And we submitted that in 2008, met with EPA a few times. They needed more time. They need more time. In 2011, they issued, and my apologies to Nancy Stoner, who was the acting administrator for water at the time. colleague who used to be in NRDC, is now with the Pisces Foundation, but she had the, it's still the Stoner memo, and basically they said, hey, look what we're coming out, we're putting together this framework to work with the states. And they developed all of these elements of what a framework should be, and there are very, very few goals, timelines, numbers like we've been talking about in this. And a lot of the states saw this, oh, if we do this, we don't have to develop these numeric criteria. So they basically issued that, and then they sent us a letter saying, your petition is denied. And obviously this isn't all they said, but they said, while the EPA is in agreement with many of your environmental concerns, we are denying the petition for the reasons explained below, and I can provide you that if you want. We do not believe the comprehensive use of federal rulemaking authority is the most effective or practical means for addressing these concerns at this time. So basically they said, we don't disagree that it's a problem, but we don't want to rule on this. We don't want to say, yes, criteria are necessary, or no, criteria are not necessary. So, okay. So we didn't like that. And we filed suit. And basically we said, arguing that EPA needs to make a decision. And we used Massachusetts versus EPA was one of the foundational cases. And I'm not going to get into that because A, I have 5 minutes, and B, I'm not a lawyer. So you can you can talk to these folks about it. And I bet it'll be. I wouldn't be surprised if it's brought up in a second. So we filed suit, 11 plaintiffs, originally 2 defendants, and then there were a couple interveners as well. And we have the representative of quite a few of these. Also, which just blows my mind still, that all of these are State of Louisiana, Louisiana Department of Environmental Quality, Louisiana Department of Natural Resources, Louisiana Department of Agriculture and Forestry. So Louisiana experiences the problem. They're feeling the brunt of this issue with the dead zone, and they are actively fighting any sort of progress towards fixing the dead zone that would have anything that uses anything close to the R word of regulation. So we sued, and it was a mixed decision in the district court, and but this is the I'll read. You can probably read this, but they basically Judge Zaney remanded it back to EPA, saying basically you need to make a decision. You need to say yes or no, and that was appealed. And then in the circuit court, it was basically remanded back to Judge Zaney, saying that EPA doesn't have to give a yes or no answer. It can be we're not giving an answer as long as that response is firmly grounded within the statute, within the Clean Water Act. And so that's kind of where we are right now with this case. There were arguments a couple months ago, and we're basically waiting on Judge Zaney's second decision on that. So, like I said, Louisiana is no help on this. I mean, my personal thought is the Attorney General of Louisiana should be suing Iowa, should be suing Indiana, should be suing Illinois about polluting downstream waters. But they are taking basically the opposite tack and trying to actively say that the dead zone's not a problem, even if there is, there's nothing we can do about it anyway. So we were talking about the 305B report, and Category 5. You heard this last is the 303D list, the impaired waters list, and then 305. Then there's the 4B category, which Louisiana has been trying to put the the dead zone in, the waters that include the dead zone of the state. And they're basically saying, we don't have, TMDL doesn't need to be developed, and even so, we don't have the capability to do it, which is true. Louisiana cannot develop a TMDL for the entire basin. And so they basically say, fishing's good, so we don't need to do anything. That's what that first thing there is. And then also the TMDL development for coastal subsegments will not resolve the issue. They're basically trying to say we have this Gulf hypoxia action plan that is going to fix this problem, even though the action plan has no solid deadlines or benchmarks, or it's basically reduce the size of the dead zone. So, just to, before I go, with my last minute, there is we were supposed to reach that goal I was talking about, the 2,000 square miles, by 2015. And, it's 2015. And we have not fixed the problem. We have not really made significant inroads into reducing significant amounts of the pollution that's causing the dead zone. And so basically what happened is the EPA said, you know what, we still think this is a good goal, the states still think this is a good goal, we're just going to kick the can down another 20 years. So now the goal is to reduce the size of the dead zone to 2,000 square miles by 2035, but we still don't have solid plans. And if we don't reach that goal, there are absolutely no apparent consequences to the states for developing these criteria. And we feel that developing these criteria is the first step. Whether it turns out to be a multi-state TMDL or some other program, we need to first have these numbers so we can start allocating loads to each of the pollution sources. I think that's it. Oh, and Oliver Houck gave this, showed me this slide a couple of years ago. If you can't see it, it's EPA cleaning up the Chesapeake there and saying, and then everybody else in the country saying, oh, if they clean up the Chesapeake Bay, who will be their next victim? And we're trying very hard to make sure Mississippi River is not the next victim of cleaning up. Thank you.
So our final speaker, and we will have some time for questions, does not need introduction because he just spoke on the last panel. And I promised him he could talk about a lawsuit that he won, so the floor is yours.
I think that's the least you can do is let me talk about something I want. But I wanted to talk about really two things. One is an experience, again in Florida, just except everything but the Everglades, that partly influenced EPA's views about TMDLs and developing particularly numeric nutrient criteria. And the second is I'll tell you a little bit more about Judge Zaney's decision and the Fifth Circuit's decision in the lawsuit that was filed. With respect to Florida, what the record reflects is EPA's generally long-term view that eventually numeric nutrient criteria have to be used as a tool for regulation. And that's for simply practical reasons. You know, you need a number to sort of set individual limits. And so what happened was the state of Florida spent between 2000, and they've taken this position consistently since 1998, and the 2011 framework memo that was discussed a few moments ago continues that view that ultimately they need numeric criteria. And so the state of Florida from 2003 to 2009 spent millions of dollars, I'm not sure how many millions, but it was a lot, to develop numeric nutrient criteria. And then what happened is there was a lawsuit that was filed saying this is taking too long, and EPA into a consent decree in which it made, in fact, a necessity determination, which is what the plaintiffs are seeking in the Gulf Restoration Network lawsuit. They made it, the EPA did make it, they made it as part of a consent decree, so it was federally enforceable by the court, and then went ahead and started to develop federal numeric nutrient criteria. What happened after that is both the state of Florida, the government, and industry was up in arms, partly because of the fact that the state had been spending all this time trying to develop these criteria and essentially had the rug pulled out from under them. And so it was a very unpopular move, almost universally, except for the environmental groups that brought the lawsuit that resulted in the consent decree. So EPA did develop numeric criteria, and after that, two things happened. One is those criteria were challenged in federal district court in Florida, and the challenge came before Judge Hinkle. And the second thing that happened is that due to the immense unpopularity of what EPA did, probably in part, I'm presuming this is the case, they encouraged the state of Florida to develop its own numeric standards, and the state, in fact, did continue with the effort that had begun in 2003. So in terms of the really important part of the Florida litigation, Judge Hinkle upheld almost everything EPA did, with one very important exception, recognizing the difference that nutrients play in the water, in a receiving water, in contrast to toxic pollutants like metals, zinc, chromium, PCBs, all those things. The court held that EPA's method for establishing numeric criteria was in fact unlawful. And to go back, to understand that, you have to recognize that, in fact, some nutrients are necessary in all watersheds because they make plants grow, and the plants that grow in the water help the fish and the macro invertebrates. And so you actually need some nutrients in water, otherwise you'd have a different kind of dead zone. And so the question is how much, and the narrative standards that Florida had and that almost all states have is that the levels have to be such that they allow for don't create an imbalance, that they allow for a balanced population of flora and fauna. So what happens is that the problem that Matt has described is if you have too many nutrients, essentially the flora wipe out the fauna because you get plant growth, including algal blooms. They fall to the bottom, they decay. When they decay, they take up a lot of oxygen. If they take up more oxygen than is coming into the water, then you don't have enough oxygen for the fish, and the fish die. And so that's the problem. But the difficulty is that figuring out the right level depends upon what the water is like. And one example that Nina Bell talked about was shade. It does two things. It changes water temperature, but what it also does is reduce the impact of nutrients because plants need sunlight too, and that varies from stream to stream as well as temperature and flow and the nature of the stream bottom, which will affect the impact that nutrients have in any particular water body. So what EPA did for its numeric criteria is it took kind of, I wouldn't say the easy road because this was complicated too, but they divided Florida into regions, and then they took for each region, they said, well, let's take the most pristine streams we can find that we know are least affected by nutrients, and we'll use those as the basis for our standards, and they did it on a regional basis. The problem with EPA's methodology is that if you add more nutrients than what the most pristine streams in Florida have, it's not clear that that's going to cause harm because its harm comes when the plants when the flora overwhelms the fauna. And they had no evidence that if you increased the amount of nutrients in the pristine streams by any particular amount, that would cause harm. And so the water quality criteria that EPA developed were not based on protecting the use, which is what's required. And so Judge Hinkle found that in fact this was not a valid basis and vacated those numeric standards. And the reason that's important, or one of the reasons that's important for what we're talking about for the Mississippi River Basin, is that the developing standards for nutrients is not the same problem as developing standards for chromium or PCBs or any other kind of, even sediment. And so you're talking about a very, very difficult problem. The second lesson that EPA and others learned from the Florida experience is that this is really hard and it does take a lot of resources. And EPA essentially was saying, if we did what was required in that petition, it would take a long time and we couldn't do anything else because the resources it takes are too demanding and we simply don't have them. And so that resulted, that was probably the primary basis for the denial of the petition that was filed by the Gulf Restoration Network. And so that is sort of in a nutshell the problem that the lessons of Florida and the impact that they had on how EPA would react to a petition like this one and how it will react in the future. Now, getting to the Mississippi River Basin case, there's two things I want to say. Since I had to describe the case that I lost in the last panel, I argued the winning position in front of Judge Hinkle in Florida, and although I had much less impact on the Gulf Restoration Network, that big group of interveners that was on the left, those were clients that we represented as well, but probably had very little influence over the ultimate decision. Now, there were two issues, again, to go back to the case and look at it from a legal question. There were two issues that were decided by both Judge Zaney and in the district court and by the Fifth Circuit. The first was EPA took the position that there could be no judicial review of EPA's refusal to decide the petition that was filed in front of them. And they've taken this position before. I mean, generally the Justice Department takes the positions that maximize the discretion of the agency, and that's true of all agencies in almost all cases. And so essentially what they were arguing was an expansion of the doctrine that you find in Cheney versus Heckler and some other cases where the courts have said that, or rather the Supreme Court has said that even although the Administrative Procedure Act creates a presumption of reviewability, there are exceptions to that, and one of the exceptions is if there's no law to apply. If the statute is such that it doesn't give any handle for the judges to decide whether or not what the agency did was within its authority. And so the Justice Department argued that the necessity determination under the Clean Water Act, which basically says that EPA can issue its own water quality criteria in lieu of state criteria if it finds that it's necessary to meet the requirements of the Clean Water Act. The Justice Department said, well, that's too vague, and so this is an unreviewable decision. And Judge Zaney rejected that argument, and the Court of Appeals did too, after long analysis, said, yes, in fact, there is some law to apply. There's not a lot. It's a pretty vague standard, but there can be judicial review over EPA's decision. Where the district court somewhat split from, or where the Court of Appeals split from the district court, is in how they applied the case in Mass v. EPA. Massachusetts v. EPA was the Supreme Court decision that said EPA had to decide whether essentially greenhouse gas emissions caused endangerment under the Clean Air Act. And the distinction that Judge Zaney pointed out, but nonetheless did not follow up the way the Court of Appeals did, Judge Zaney noticed that in the Clean Air Act, in this particular provision of the Clean Air Act, there's no state alternative. The only regulator is EPA. And so if it decides not to regulate, there will be no regulation under this provision. This is over motor vehicles under the Clean Air Act. In contrast, under the Clean Water Act, the state is supposed to act in the first instance. So when EPA decides it prefers to work with states, that's a different question. Nonetheless, Judge Zaney applied Mass v. EPA broadly and said these two provisions are close enough, so I believe that if EPA had to act under the Clean Air Act, it must act under the Clean Water Act as well. The Fifth Circuit disagreed because when it looked at Mass v. EPA, what it found was that the court had a third alternative. The Supreme Court said, yes, you can decline to review a petition or provide an answer to a petition if you find reasons grounded in the statute, if you provide a reasonable explanation as to why you're not deciding this decision. And part of what motivates this is the control of agency resources. The concern is that if EPA or any agency had to decide a decision, rather had to make a decision on a petition that requested regulatory action, requested agency action, and then of course it would have to follow up. Essentially the use or the allocation of agency resources would be governed by the petitions it received. Once you assume that an agency has more to do than it can do, which is certainly true with EPA and true with a lot of other agencies, if you force them to respond and then follow up on petitions, then the squeaky wheel will indeed get the grease. And the problem is that it will interfere with an agency's ability to allocate its resources and make the most efficient use of them, because it will be simply following whatever court decisions come down as opposed to its own views. And so both judges said that the issue raised by the case, which is the first, reviewability, yes, it's reviewable. Second, should there be an order issued to require EPA to respond to this petition and make the determination that the plaintiffs have requested? Yeah, that issue is one where great deference is given to the agency. For the district court, the Gulf Restoration Network argued that only scientific and technical factors can be taken into account when EPA rules on this or makes a determination on this issue, and it followed the Clean Air Act case, the Mass v. EPA. Judge Zaney said, no, that's not true because the Clean Water Act has a state option and has other policy options, and the agency's free to consider its policy agenda and doesn't just have to make a technical determination. The Fifth Circuit made a similar determination in direction to the district court and said the only thing that is required is that the agency's reasons be grounded in the statute. And so now it's back on appeal, or it's back on remand to Judge Zaney, and so he will look at EPA's justification and has to decide whether that's sufficiently grounded in the statute. And the question then will be, with respect to the statute, do you look at the entire structure of the statute, which in this case includes an option for working with states, or are you limited to the technical issues in the statute? And so that's what Judge Zaney will be looking at. The other thing is just as a kind of my sort of personal views about the problem and delays and things not happening, is that like Chesapeake Bay and certainly for the Mississippi River Basin, these are very, very difficult problems. You're talking about changing the way land is used. You're talking about what will be definitely sacrifices that will have to be made in order to reduce nutrients or other pollutants going into a wide area. If you look at for example, the Chesapeake Bay TMDL, and I hope John is here because he may want to respond, but the deadline for simply introducing the measures under the Chesapeake Bay TMDL, which was adopted in, I believe, 2012, was 2025. So that's 13 years simply to put the measures in place, but that doesn't mean that the water quality will instantly go down to the level that is demanded to meet water quality standards. It will be more years before that's happened. And I think someone mentioned that, the lag time, and for example, in Maryland, I think it was the Science Advisory Board, or the Geologic Survey, one of the think tanks or analytical bodies, scientific purely, looked at this and said, what bleeds into the bay if fertilizer is put into the ground on day one, it may be decades before that works through the system. And so controlling the amount of fertilizer will have an impact. Controlling how it's used will have an impact. And in fact, those are the best management practices that are applied to agricultural organizations. But the response within the receiving water may take, in this case of Chesapeake Bay, for this instance, it could be decades. You would expect for the Mississippi River Basin, you're talking about decades. And that's true no matter how or when or who ultimately makes the requirements. These are not only complex, but these are areas where the water bodies are very slow to respond. So, at least I hope I got a silver medal.
Yeah, no, you got it. We have some time for questions. We have microphones. How about David? You can project.
I can just, yeah.
Okay.
So this is for all three of you. I'm kind of interested, particularly for Richard. On the issue of phosphorus criteria and standards. What do you think your clients would think of an approach under which there was a numeric criteria that was kind of the presumptive criteria for minimum, for phosphorus levels, but with the ability to kind of do case-by-case, segment-by-segment adjustments based on the actual conditions in that stream? If you had some objective standards, such as like an ecological standard, the right balance of macroinvertebrates and so forth. I'm just curious if that may be a way out of this kind of debate we've been having over numeric phosphorus criteria.
Well, I guess that's actually a complicated question. I'll answer it in as many pieces as I can. I think the way we look at it is that, yes, there's no objection to having numeric criteria in waters. It's just that one size really doesn't fit all, and so they would have to be accurate. And in terms of the means of achieving them, in fact, and certainly in the Chesapeake Bay, they said that it could have been the Department of Agriculture found that 96% of the land was having conservation practices, erosion control of the agricultural land. And I think that as a practical matter, it's those best management practices that would have to be installed and should be installed. And so in terms of the agricultural community, they're saying we just want them to be sensible requirements. And what you're talking about is a bunch of things. You're talking about possible buffer zones next to streams. You're talking about simply how land is plowed, that the fertilizer that is put on the land is not more than what is necessary. And there are things that you can do to control runoff that they want to do anyway because it's a better farming practice. And those things, I think everyone would agree should be implemented. And that's probably how you get there.
I can't talk about nutrients, but in the context of TMDLs, but I think that what you're suggesting is consistent with what I posited at the end of my talk, which is that these numbers are important, and it's important to fit these concepts of how do we fix this into the existing regulatory scheme. And what you were suggesting sounds to me like what we have regulations in Washington State for variances and use attainability analysis. And I think that rather than having the agency and all the regulators throw up their hands and say, this is an impossible situation, let's just make a plan, no numbers, whatever, happy talk. Let's go ahead and fit this into the regulatory structure by saying, okay, this is not an attainable use here. This alternative number is appropriate, and to run that through the process. That's in my mind how it's supposed to work.
Yeah, I'd like also I think that with the phosphorus criteria, that's like you said, that's how water quality standards work. Is that you set the standard, but you have site-specific criteria, and you have variances, you have tools in which that if it isn't appropriate for this water body, then you can make an argument. If you have a scientifically sound argument, then you can change that. But the stumbling block is that that's what all of the states are saying. Like our waters are unique and special, and everyone is a special snowflake that cannot have so the number that you're proposing doesn't apply to us. But if you don't have that starting basis, then you can't start doing the variances and all that kind of stuff. So I think having that bottom line number, even though nutrients are complicated. It isn't as simple as like mercury and arsenic and things like that, and that it's necessary. I think that's a little bit of a red herring in that we could remove all of the human sources of nitrogen and phosphorus, and the waters would be just fine. But that gets away from your questions.
But it's not all states. I mean, Vermont has an approved water quality criteria for phosphorus that is built around this idea of presumptive minimum numeric criteria, but the ability to adjust based on objective ecological standards.
And I think, just to answer your question, I think Florida, when they adopted the state criteria, had a similar kind of mechanism where they had the ultimate test was what does this do to the flora and fauna in the particular receiving water, and that's not something that we object to, or that the agricultural community objects to at all. I think that's what they want, right, or part of what they want, and the other part is that when their requirements are made for how they farm, that they be sensitive to the needs of farming.
Another question?
I was going to say the same thing, that Florida has the site-specific alternative criteria and its numeric standards. But my question is, so everybody's talking about BMPs, but we know that BMPs can only take you so far, even if they're done well. You're still putting nutrients into the system. We need to take nutrients out of the system, not just reduce the amount we put in. And we've all, some of us have talked about the legacy phosphorus problem and how long it takes to cycle out of the system. So are there plans or to do these sort of collect ag or non-point source water and do regional treatment systems like what I was talking about with the Everglades, to not just reduce what we're putting in, but actually take more out?
I would say no.
You stumped us.
But it is like an antithetical example to what that is would be the Des Moines Water Works, which for a drinking water standard, the nitrate drinking water standard, they have to crank up this reverse osmosis machine that costs hundreds of thousands of dollars a day to operate whenever the nitrates get too high. And so they take the nitrates out for drinking water purposes, and then they just dump them right back into the Des Moines and Raccoon Rivers whenever it gets past the system. So, my answer would be, I don't think anybody's thinking about that.
For Richard, this is sort of following up on David's question, but at a much higher level of generality. I'm curious, there's a couple of basic questions. Does the Farm Bureau Federation thinks nutrient pollution is a problem that the country needs to address? Or is it just something we have to live with because it's a price of progress? If they think it's a problem, do they think it ought to be addressed at the national level or at the state level? And if there's a national legal / policy solution that we should embrace, what is that? I understand you're in the position of fighting what you think is misguided ideas, but I'm sort of curious what the Farm Bureau's positive agenda is.
Yeah, unfortunately, again, the answer is I don't know. I can say that that the Farm Bureau supports using good farming practices that would reduce nutrient pollution. I can also say that they think that should come from the Department of Agriculture or the states or State Department of Agriculture, who simply know more about farming and will be better, will give requirements that they can more easily live with. In terms of the real, the 30,000 foot solution, I actually don't know what their position is.
Go ahead.
Quick Spokane River question. Where are the PCBs coming from? And more specifically, who are the point source dischargers? Because PCBs are usually a legacy pollutant. And how much of the PCB problem is coming from current point source dischargers?
Excellent question, thank you. The answer to that is that they are legacy for the most part. They're getting into the river. The dischargers are municipal sewage treatment plants, 3 or 4 of them, municipal stormwater, which carries a lot of PCBs. And then there is the aluminum plant that I mentioned. They draw water for their process from groundwater. Their groundwater is contaminated with PCBs. The other major industrial point source in the Washington part of the river is the Inland Empire Paper Company, which is recycling paper, a lot of which comes from China and has PCBs in it. That's the only identified significant source of new PCBs in the basin. The rest of it is all legacy, and it's just getting into the river from various upland places and probably hot pockets in the sediments of the river as well. They really are having kind of a challenge tracing all of this, and that's one of their big arguments about why they shouldn't have to do a TMDL, is because it's not fair to put it on these point sources when we don't know where it's coming from. But I think that the solution is about putting good, most modern, cutting-edge technology treatment. There's a new sewage treatment plant for the county of Spokane, which has incredible PCB removal performance. I challenged that permit. My expert in that case said he'd never seen anything like it. So there is some removal technology that's pretty good. The other part of the thing is tracing it upstream, and that's a costly, time-consuming process, particularly for the stormwater and the sewage treatment plants. They've just got to keep going upstream and looking for it and digging it out of the ground or moving it where they find it.
I just add to that, PCBs are special because their use has been banned for decades. So you won't find any new uses of PCBs. It's all stuff that got into the system decades ago. And the other problem is that they don't break down. So once they get in, they're not just going to decay. You have to either remove them or find a way to isolate them.
Yeah, I think a lot of it's in the sediment in the river. A lot of the part that they can't find, and it's just getting kicked up and pushed down the river over time.
All right, well, I want to get my gold star too, and it's 12:20, and I've been told by the conference organizers that lunch is around the corner and some fabulous things going on this afternoon. So thank you, and a big round of applause.